The decision that a parent has to make on the ongoing basis as they raise their children are many and varied. And if both parents have parental responsibility, which is something your solicitor can help you with, if both parents have legal parental responsibility, then both parents should have a say in every single decision. If they disagree, I'm afraid that's when solicitors or mediation or other forms of dispute resolution have to come in, because of course these things are very near to the heart. Whether or not your child goes to a particular religious school or not might be really important to you, and it might be worth fighting over. Or, for instance, whether or not your child goes to a particular church, synagogue, mosque. All of these decisions can be very contentious. The family courts are used to dealing with these, and as solicitors at the Law House, we're also used to navigating these treacherous waters with as much help to our parents in mitigating the damage that these things can have on the children as is possible.
In situations where parents separate, it can be difficult to agree who the children will live with and who the children will have contact with, which parent will be the resident parent and which will be the non-resident parent. In this day and age, shared care arrangements or shared residence arrangements are becoming increasingly common. That means that a child doesn't have to choose, or parents don't have to bash out an agreement as to which parent will have the children with them on a full-time basis. It means that a child can divide their time, sometimes equally or sometimes unequally, between both parents, and therefore neither parent feels that they're at a disadvantage or have a lesser role within their children's lives. So it's important that in many cases where it's appropriate, a shared care arrangement is encouraged. There are, of course, circumstances where, for whatever reason, that isn't possible, and in those circumstances, residence orders can be granted to one parent, but it is usual and best practice in those circumstances for a contact order to be granted to the other parent, to allow it to be clear exactly how much time will be spent with each parent and when. In circumstances where parties are unmarried but have children, they are governed by very different law to the law that governs married couples. And that's very important to know, but is often not recognised by many people who choose not to marry but choose to have a family. In those circumstances, there is no obligation on one parent to support the other parent any further than child maintenance. And often child maintenance is not sufficient to fully support the child or to help to provide a home for the child. In those circumstances, there are applications that can be made, and it's often known as a Schedule 1 application, which can be made to the court by one parent to try to oblige another parent to provide for the child. Child maintenance is something that can be agreed amicably between parents. Parents can decide amongst themselves how much they feel the non-resident parent should pay to appropriately help provide for the child. However, there are inevitably going to be circumstances where parents don't agree in relation to what level of maintenance is appropriate, and in those circumstances the Child Support Agency is a government body that's able to step in and provide accurate calculations and simple calculations as to what level of maintenance is actually appropriate. In those circumstances where, for example, a non-resident parent isn't paying what they're supposed to pay, the Child Support Agency, known as the CSA, can set up certain arrangements to ensure that payment is made.